Provided to both parties copies of the proposed jury instructions that the court intends to use to charge the jury. Have you both had an opportunity to review the proposed charge?
Yes, Judge.
Yes, Your Honor.
And are there any objections from the state?
Yes, Judge. The state has several objections. Objections are, I guess, more or less housekeeping objections in the term definitions section on page 2 of the charge.
Page 2?
Yes, Judge.
Okay.
Missing from the term definitions is the definition of act, which is defined by statute and is also an element of murder under 1902b2, where a person intends to cause serious bodily injury and commits an act clearly dangerous to human life.
I can add a definition for act. You want the statutory definition?
Yes, Judge, and if it's convenient for the court, it's included in the state's proposed charge, so it should be pretty easy to carry over.
And your next objection?
The second objection is, again, just housekeeping, the inclusion of the definition of person in the term definitions. Unless I've just completely read over it, the word person is not included in the definition of the offense of murder. Individual is, and individual is already defined in the charge as a human being who is alive. So person, while defined, is never actually used anywhere else in that part of the charge. And so it's just sort of
You object to the definition of person being there?
Yes, Judge.
Let's go back to your first one. You'd like to add the statutory definition for the term act.
Yes, Judge.
What says the defense?
Your Honor, we object. We have no objections, first off, to the charge as it's written. We believe that the jury can use the definition of act as it's commonly used.
We'll use the statutory definition.
Thank you, Judge.
And then, does the defense have any objection to the definition of person being included?
We would like it included, Your Honor, because person does appear throughout the jury charge. Like the first full paragraph on the bottom of page 9 begins with a person's conduct that would otherwise constitute a crime of murder, etc. So just, it's not listed in the elements, the essential elements of the offense of murder, as it is throughout the charge. We just would like it to remain there.
And you object to it being included?
Yes, Judge. At least at the very beginning, it seems superfluous in the term definitions as they're applied to the offense. If the word person does appear later in a defensive issue, the definition could go in that section of the charge the same way the term reasonable belief is used in self-defense and it's defined later in the charge. It puts the definition of the word with the part of the charge that the jury needs to understand.
In response, Your Honor, on top of page 4, the word person appears in the definition of manslaughter.
Your first objection concerning act will be sustained. Your second one concerning person will be overruled.
Very good.
The next one?
Judge, at the top of page 6, in the list of the elements of deadly force in self-defense, the court's charge presents as the alternate second element of self-defense that the person, I'll just quote it, to prevent the other's imminent commission of aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. The state objects to including each of those offenses for the reason that there is no evidence raised in this trial that the defendant reasonably believed there was an imminent commission of aggravated kidnapping, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. All there is in this case is the defendant's stated belief from the witness stand that she thought Mr. Jean was going to kill her. That at most would be murder. It would not constitute any of the other offenses. Given that there's no evidence of those offenses and that those offenses are not fully defined in the charge, including them would invite the jury to engage in speculation in reaching a verdict, and it's an improper charge on the defensive issues that have been raised by the evidence.
Mr. Muller?
Your Honor, this would assume that Ms. Guyger would have had to testify that I thought that the person that I believe was in my apartment, which was my apartment, was going to not just kill me, but kidnap me, sexually assault me, rob me, or burglarize me. You know, her testimony, I believe, was that she was scared. And, you know, when there is an actual intruder in a person's home, any of these acts are possible, you know, as case law has shown. So we object to removing the supposed offenses that she may have perceived when she walked into what she thought was her apartment.
And Judge, may I approach?
I have a case in the court.
So just so I'm clear, Mr. Gladden, you would like the term limited to prevent the imminent commission of murder?
Yes, Judge, that's correct. And the case I just provided the court, Judge, is Shaw v. State, 243 Southwest 3rd, 647. I've already got the court's copy flipped to the highlighted portion I want to cite to, which is at the top of page 11 of the printed copy, where the Court of Criminal Appeals reminds bench and bar that the evidence must rationally support a jury finding before defensive instruction is required. And then the court specifically says if a jury were instructed as to a defense, even though the evidence did not rationally support it, then the instruction would constitute an invitation to the jury to return a verdict based on speculation. Just like Mr. Mola said, at most, a statement by the defendant that I believed he was going to kill me says, oh, he may do other things. What he may do is pure speculation. It's not supported by the evidence. And the jury should not be invited to speculate about possible things that the evidence doesn't show.
May I respond, Your Honor? I'm sorry, you were
Of
agreeing.
course you may. Go ahead.
Your Honor, if in a case where an individual, a defendant, let's say, enters a person's home, a person's habitation, an actual intruder, courts, in case law, courts have reached conclusions that when that happens, anything is possible. To sustain the court's objection would mean that, again, Ms. Guyger would have had to state, well, I thought other than, you know, he was going to hurt me or kill me, that he was also going to commit these other enumerated offenses. These offenses that are listed, Your Honor, are the types of...
Now, I do know you understand the rules of statutory construction.
Yes.
And you know what these phrases or stand for, as well as the placement of the commas in between these various offenses.
Yes, Your Honor.
So I don't think that argument is genuine. I think that's disingenuous to presume that Ms. Guyger would have had to get on the stand and say, I thought he was going to commit aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery.
Well, no, Your Honor, I'm saying that she shouldn't have had to have done that.
And this statute doesn't presume that she would have.
Well, no,
We're going to move on from that. I'm going to reread Shaw quickly in its entirety, and I'll let you know. Your next objection, Mr. Gladden.
Yes, Judge. The state's next objection extends from the middle of page 6 to the top of page 7. This is the portion of the charge commonly referred to as the Castle Doctrine. And the state has filed an objection to the inclusion of Castle Doctrine in the jury charge. The Castle Doctrine it's a defensive issue, but it's kind of an optional part of another defensive issue. And so I think Shaw still applies. The page previously in what I provided to the court from Shaw, I think this rule still applies, that there has to be some evidence on each element of a defense that, if believed by the jury, would support a rational inference that the element is true for the defense to be included in the jury charge. And the Castle Doctrine is a defensive issue with a twist. It's a presumption in favor of the defense as opposed to just a statutory defense. And so what this court is tasked with deciding is whether is, I want to make sure I quote the statute accurately for the court. In Penal Code, section 2. 2.05, that there has to be sufficient evidence of the facts that give rise to the presumption for the issue of the existence of the presumed fact to be submitted to the jury. Now, for Castle Doctrine, the facts that give rise to the presumption are the three parts that, one, the defendant has to know or have reason to believe either the victim had unlawfully and with force entered the actor's occupied habitation, knew or had reason to believe that the victim was attempting to remove unlawfully and with force the actor from the actor's habitation, or knew or had reason to believe that the victim was committing or attempting to commit a violent felony. 2, the defendant did not provoke the victim. And 3, the defendant was not otherwise engaged in criminal activity. There has to be sufficient evidence of the facts that give rise to that, of those three facts, to give rise to the presumption. The state's argument in this case is that there is no evidence to give rise to the first part of this presumption. There's no evidence the defendant knew or had reason to believe Mr. John had entered the defendant's occupied habitation. The defendant wasn't in the apartment when she said she formed the belief that someone had entered. The defendant never testified or gave any reason for her to believe that Mr. John was trying to remove her from the apartment. And all the defendant testified to about believing that she would be killed is, I believed that Mr. John was going to kill me. But there were no facts that would support that belief. There was no reason to believe that she would be killed. The case I've cited the court to in our objection to the Castle Doctrine is Audie v. State, where the Amarillo Court of Appeals has said that evidence of a person who's larger than the defendant, who is lunging at the defendant, and who is yelling at the defendant is at most a reason to believe that contact may occur. Contact is an assault. Contact is not a murder. There's less evidence to support a belief of an imminent murder in this case than there was in Audie. Here the victim was no more than 13 feet away from the defendant. And the victim was saying, even in the light most favorable to the defendant, the victim was saying, hey, hey, that's it. There's no evidence that Mr. John had a weapon. There's no evidence that Mr. John brandished a weapon. There's no basis for the defendant to have reason to believe that Mr. John was committing or attempting to commit murder, much less any of the other violent felonies. So the state would object to the inclusion of the Castle Doctrine.
Mr. Mahon, do you have a response?
Yes, Your Honor. Thank you. Your Honor, the Castle Doctrine is under Penal Code Section 9.32b. It is a defensive issue. In Hamill v. State 916 Southwest 491, Court of Criminal Appeals case 1996, I'm just going to quote the holding. It is well settled that an accused has a right to an instruction on any defensive issue raised by the evidence, whether that evidence is weak, strong, unimpeached, or contradicted, regardless of what the trial court may or may not think about the credibility of the evidence. Now, the evidence showed that she believed that she was entering her apartment. There was an intruder, she believed, in her apartment. Now, whether that belief was reasonable, as you said, Your Honor, yourself, that is for the jury to decide. So we believe the 9.32b instruction should be included for the jury to decide whether that presumption is available to Ms. Guyger.
And Judge, I would disagree that Hamill applies in this case because the defensive issue is self-defense. The reasonableness question for self-defense is not the belief that it's her apartment or not. The reasonableness inquiry for the jury is whether the defendant believed deadly force was immediately necessary. The Castle Doctrine creates an almost irrebuttable presumption that that belief was reasonable if the jury finds that the facts giving rise to the presumption exist. That's why the court can't use the standard in Hamel for deciding whether the Castle Doctrine applies. Instead, there is a statutory standard for whether a presumption applies, and it's not whether there's any evidence, no matter how weak or impeached. It's whether there is sufficient evidence. And in fact, the court can go on and decide that if the court is satisfied that the evidence as a whole clearly precludes finding beyond a reasonable doubt of the presumed fact, the court can exclude the presumption even in the face of sufficient evidence. What I'm arguing to the court here is simply there is not sufficient evidence based on the statutory standard.
Briefly respond, Your Honor.
No, I don't need any more responses. I've read a ton of self-defense cases and issues, and the court will overrule your objection, Mr. Glad.
Thank you, Judge.
Your next objection, sir.
The state's next objection is at the top of page 8, at the very end of the instruction on failure to retreat. In all fairness, the court's charge, as I understand it, tracks the statutory language of failure to retreat. But the case law has approved what I call a contrary instruction that should finish by, after telling the jury that if they find the 3 elements of no duty to retreat, if they find the 3 elements, they may not consider the defendant's failure to retreat. The court can also include the converse instruction: if you do not so find, you may consider any failure of the defendant to retreat that might be shown by the evidence in deciding whether the defendant reasonably believed her use of deadly force was immediately necessary. That's included in the state's proposed charge, and the state would ask that it be included in the court's charge.
We're going to object to the inclusion of Mr. Gladden's suggested language. I think that language is confusing, and I don't believe that it's supported by the evidence. And, again, the proposed instruction, Your Honor, that you provided tracks the language exactly, the statute exactly, the language of the statute. And that's my objection.
The one issue here concerning the defendant's duty to retreat is the one that has given the court the most difficulty, because presuming that the jury does not find that the mistake of fact as to being in her own apartment was reasonable, that I am wrestling with whether or not the duty to retreat should be included. So let me just think about that for just a minute. Did you have another objection, Mr. Glad?
Yes, Judge. The state's next objection is to the first full paragraph on page 8. When a person is attacked with unlawful deadly force or she reasonably believes she is under attack or attempted attack, going down to viewed from her standpoint at the time to protect herself from such attack or attempted attack. This paragraph is commonly referred to as an apparent danger instruction or a multiple assailants instruction. It's kind of a hybrid because it also says by one or more persons. Can I approach the bench again, Judge?
Sure.
I've provided the court with Beltran de la Torre v. State, It's from the Court of Criminal Appeals 2 weeks ago. So it's not yet been reported. It's number PD 0561-18. The apparent danger instruction, well, let me just read what Beltran says. To ensure compliance with Article 3614, a trial judge should, as a general rule, avoid including non-statutory instructions in the charge because such instructions frequently constitute impermissible comments on the weight of the evidence. At issue in Beltran del Torre were two non-statutory instructions, one in favor of the state, one in favor of the defense, both of which the court said were non-statutory, and it told the jury what it could consider outside the realms of what the statute provided. And in both instances, the court said that those instructions drew the jury's attention to a particular type of evidence in deciding an issue, whether it was in deciding the guilt of the defendant or in deciding a defensive issue. And the court said that that was improper and constituted a comment on the weight of the evidence in both cases. The apparent danger instruction, as used traditionally in the past, would constitute the same type of instruction, because what the statute for self-defense provides is that a person is justified if they reasonably believe that deadly force is immediately necessary. A reasonable belief is defined by statute as a belief that would be held by an ordinary and prudent person in the same circumstances. What the Court of Criminal Appeals has said in Valentine v. State, and what the courts of appeals have held in applying that, is that an instruction that tracks the language of self-defense and includes the statutory definition of reasonable belief communicates to the jury the principle of apparent danger, because it's a question of what did the defendant believe and was it reasonable. But actually putting in the apparent danger instruction directs the jury's attention to a specific type of evidence, that is, the standpoint of the defendant's viewpoint, without statutory authorization. The apparent danger language is not in statute, and so it should not be included in the jury charge.
Let me be clear, exactly which sentences or paragraphs are you asking to be explained?
For this objection, Judge, I'm objecting to the entire first full paragraph on page 8. And as a heads up, I'll be objecting to the next full paragraph as well, but I was going to divide that out.
So the paragraph that begins when a person is attacked.
Yes, Judge.
And you said your next objection goes to the next paragraph?
Yes, Judge. I would object to the next paragraph too, for multiple reasons, one of which dovetails from the apparent danger objection. It reads in the court's proposed charge that the next paragraph is a part of the apparent danger instruction, so I'll tie it together. The language taken from that next paragraph, the second full paragraph on page 8, appears to be taken in part from Article 3836 of the Code of Criminal Procedure. There's several problems with including that in the jury charge, especially including it here. The first is Article 3836 is not limited to the reasonableness of the defendant's belief, whether as a part of an apparent danger analysis or not. Article 3836 is a rule of evidentiary admissibility in a prosecution for murder. It's a basis for admitting certain types of evidence. It's neither a legal issue that the jury should be instructed on. It's a rule of evidentiary admissibility, and to the extent 3836 allows for specific uses of that evidence, that would be appropriately put in a limiting instruction, such as in the 404B instruction, where the jury is instructed, you may consider extraneous bad acts for the 404B purposes and the state of mind of the defendant, and for no other purpose. And that's sort of where that phrase state of mind comes from in the traditional 404B instruction. But to include it in the apparent danger instruction, especially as a full instruction, it directs the jury's attention to a specific piece of evidence without really statutory authorization for doing so. And so it's a comment on the weight of the evidence. And it applies to an apparent danger instruction, which also should not be included in the charge. So the state objects to both of those paragraphs.
Your Honor, I'll address the 3836 instruction. First off, Your Honor, that is a statutory instruction. Mr. Gladden said so. The state, Your Honor, relied on 3836, as you recall, to admit certain evidence that the defense objected to. So now the state doesn't want to use 3836 because it doesn't benefit them in the jury charge.
Judge, if I can respond to that, we don't mind.
You will.
Okay. Okay.
Second, Your Honor, the case that Mr. Gladden handed to Beltran de la Torre, on page 11, star 11, I don't know where it is, Your Honor, on what he handed you on the state, page star 11, the Court of Criminal Appeals continues and makes an exception to what they discussed as a rule. It's not a new rule of case law, Your Honor. But the court said a jury charge may properly include definitions for non-statutorily defined terms that have a known and established legal meaning or have acquired a peculiar and appropriate meaning in the law, as where the words used have a well-common law meaning. Apparent danger, Your Honor, fits right in the parameters of the discussion of the Court of Criminal Appeals of the exception they made in Beltran de la Torre. Such terms are considered as having been used in their technical sense. It is not error for the trial court to include a precise, uniform definition to guide the jury's deliberations. Your Honor, these two paragraphs do not divert the jury's attention to any particular evidence. I know Mr. Gladden said it does, but he hasn't identified what that evidence is that would make it an improper weight of the evidence or comment on the weight of the evidence by the court. So we believe that both those paragraphs are allowed by the court, Your Honor. The second one is statutory. The first one is allowed as an exception in Beltran de la Torre, and we ask the court to overrule the state's objections.
Judge, the exception in Beltran de la Torre deals with words that are used in the jury charge that may have a risk where jurors may arbitrarily apply an inaccurate definition to the term if it doesn't otherwise have a statutory meaning. The issue in the law and the jury instruction in this case is not apparent danger. Apparent danger doesn't appear in 931 or 932 of the Penal Code. The jury is not being asked whether there was an apparent danger. So no definition or application of apparent danger needs to be applied. The jury is being asked whether the defendant had a reasonable belief that deadly force was immediately necessary. And the term reasonable belief is defined in the court's charge, and it tracks the definition of reasonable belief that's in the Penal Code. So there is no undefined term that is taken on a special legal meaning that the jury may misapply. So the exception outlined in Beltran de la Torre is not at issue here. The use of 3836, what I interrupted Mr. Mullet to add is one of our objections is that the word state of mind should be added to the list of permissible uses in the court's 404B instruction later in the charge, I believe on page 13. So that would adequately account for what Mr. Mullet just argued, because the jury will be told that if they find that the extraneous acts by the defendant were done, they may consider them for the purpose of deciding the defendant's state of mind, which is a permissible use under 3836, but it ties it into the limiting instruction under 404B as a proper instruction for the jury.
So you want to tie that into my limiting instruction that begins on page 12, the last paragraph that begins on page 12, and continues to, oh, I'm sorry, I guess the first paragraph on 13, which begins even then.
Yes, Judge, it could read, even then, you may only consider the same in determining the defendant's motive, opportunity, intent, plan, identity, knowledge, or absence of mistake or accident, comma, or state of mind, if any, and not for any other purpose.
That's overruled. Next.
Judge, the state's next objection is on page 9 in the application paragraph for self-defense. About halfway down, this application paragraph incorporates the apparent danger instruction as included on page 8. That language, just as it is in the abstract, is non-statutory. It's an improper comment on the weight of the evidence. It misinstructs the jury on the applicable law, and the state objects to its inclusion in the application paragraph.
That's overruled as well. Next.
The state objects to the final paragraph on page 9, all of page 10, and the first paragraph of page 11. This is the jury instruction on mistake of fact. And Judge, this is really the crux of this case. And when I say the crux of the case, I don't mean that the state thinks that mistake of fact decides whether the defendant is guilty. This is the crux of the case because this instruction on mistake of fact is wholly inapplicable to a charge of murder based on the evidence in this case. The evidence in this case is that the defendant, viewed in the light most favorable to the defendant, the evidence is that the defendant was mistaken about where she was. The evidence is wholly undisputed about what the defendant intended to do. Murder is a result of the conduct offense. And so the intent element of murder goes to the result, causing the death. No one has disputed that the defendant intended to cause Mr. John's death. The dispute has been over where the defendant believed that she was. The case law is clear that mistake of fact...
Is that the only dispute?
Pardon, Judge?
You think that's the only dispute?
As it goes to mistake of fact.
Okay. Sorry.
The defense of mistake of fact, which is in Chapter 8 of the Penal Code, says that it is a defense to prosecution that the actor through mistake formed a reasonable belief about a matter of fact if his mistaken belief negated the kind of culpability required for the commission of the offense. The kind of culpability required for the commission of the offense is the culpable mental state. The Court of Criminal Appeals has made that crystal clear. So unless there is a mistaken belief about the kind of culpability, about the culpable mental state for murder, mistake of fact does not apply to this case. And the court has a duty to charge the jury as to the law applicable to the case. Mistake of fact is not applicable to this case unless there's a dispute about whether the defendant intended to cause a death, not about whether the defendant thought she was in her own apartment. And what I want to draw the court's attention to is the application paragraph of the mistake of fact instruction as presented to the jury. To decide the issue of mistake of fact, this is on page 10, you must determine whether the state has proved beyond a reasonable doubt one of the following. 1, the defendant did not believe that she was entering her own apartment or did not believe that the deceased was an intruder in her apartment. Or 2, the defendant's belief that she was entering her own apartment or her belief that the deceased was an intruder in her apartment was not reasonable. You must all agree that the state has proved beyond a reasonable doubt either 1 or 2 listed above. You need not agree on which of these elements the state has proved. This instruction tells the jury that for a result offense, that even if the jury believes that the defendant intended to kill Mr. John, that if she was mistaken about where she was, that the jury should acquit her. And Judge, that's not the law. And number 1 says that the state has to prove a disjunctive. The state has to prove beyond a reasonable doubt the defendant did not believe she was entering her own apartment or did not believe the deceased was an intruder in her apartment. How does the jury know which one of those they have to decide, and how do they apply that to the result of the defendant's conduct? This instruction confuses the jury. It applies inapplicable law that does not apply to this case. It's an improper comment on the weight of the evidence because it's directing the jury to consider the defendant's belief about where she was to her intent to kill. And so this jury instruction should not be in this charge, Judge, and the state objects to it.
Thank you, Your Honor. Your Honor, the mistake of fact instruction doesn't simply go to whether the defendant is mistaken as to the essential elements of the offense when there's a defensive issue involved. In a case where a defensive issue like self-defense, defense of property, defense of a third person is involved, the standard to prove beyond a reasonable doubt that the offense occurred is actually under Saxton versus State, 804 Southwest 2nd, 910. And Saxton makes very clear that if a defensive issue is raised, the state bears the burden of persuasion to disprove the defensive issue. The state must still prove the case beyond a reasonable doubt as to both the essential elements of the offense, your murder or manslaughter, and of the defensive issues. The mistake of fact, Your Honor, obviously has to apply. It only makes sense that it applies if Ms. Guyger was mistaken in her belief, not only whether she was at the right apartment or not, but whether there was an actual intruder in what she thought was her apartment. May I approach, Your Honor?
Yes.
The tender to the court, Your Honor, Guyger versus State, that is a murder case. I'm going to give a copy to Mr. Gladden. Your Honor, Guyger involved a situation where a couple of guys left a Dallas nightclub. They were bounced out of a Dallas nightclub, and they were angry about it. One of the guys, not Mr. Guyger, but one of his friends, saw a vehicle that he thought belonged to some guy he didn't like. So according to the evidence that was presented, the other guy shot a couple of rounds into the vehicle. Mr. Guyger did the same thing. He says he thought the vehicle was empty. As it turns out, there was someone in the vehicle and that person was killed. And as the Court of Criminal Appeals discusses, whether Mr. Guyger's mistaken belief that there was someone inside the vehicle, which would have obviously made an intentional knowing killing, whether that belief was reasonable was the issue for the jury to decide. Now, it may be unreasonable, it may be implausible, but because Mr. Guyger raised the factual issue, was there someone in the vehicle? Because obviously, Your Honor, if there was no one in the vehicle, he would have just damaged property by shooting into a vehicle. But there was someone in the vehicle, and unfortunately a person was killed. But the point of the Court of the Criminal Appeals, Your Honor, is that, again, Mr. Guyger thought there was no one in the vehicle, there was someone in the vehicle, someone was killed as a result of his action, so therefore he was mistaken in his belief that there was someone in the vehicle. So that was an issue that the jury should have decided. So, Your Honor, if a person for a reason that silly shoots into a vehicle, but believing that there's no one there, but in fact if someone was, and he's entitled to a mistaken fact instruction, Ms. Guyger should be as well. And although it is a concurring opinion, Your Honor, although it is a concurring opinion, Judge Keller does discuss that there should be very limited situations where if the evidence is raised that there could have been a mistake of fact as to either the essential elements or, as other case law shows, a defensive issue, the jury should be the entity deciding whether that is an issue. The 802 issue should be applicable to the case. That's it, Your Honor.
And Judge, a belief that a car is empty, shooting into a car you believe is empty negates your intent to kill a human being. If you don't believe there's a human being in the car, how can you have an intent to cause a death? This is not the factual situation in this case, Judge. The defendant testified She believed there was someone in her apartment. There was someone in what turned out to be his apartment. She pointed the gun at him. She shot center mass. There is no dispute here that she was shooting at a human being and intended to cause his death. So Granger does not apply to this situation. And to say that mistake of fact is a defensive issue that should then apply to another defensive issue is inappropriate. I don't know if this court is familiar with the commentary in the Texas pattern jury charges, but the committee there pointed out that mistake of fact as a defense, the way it's worded, because it applies to the culpable mental state, it's basically a no mental state defense. And ordinarily a no mental state defense is a failure of proof defense that should not be included in the jury charge. It's provided for as a statute, so it should be included if raised. But there is no basis for taking one statutory defense and incorporating it into another statutory defense. And in this case, the charge doesn't even do that. The charge doesn't apply mistake of fact to the justification of self-defense. It instructs the jury, if you find that she was mistaken, that she was reasonably mistaken about where she was, you will acquit her. It eliminates her legal culpability for an intentional killing based on her mistake about the circumstances. And Judge, that's just not the law, and the state objects to that charge.
The court is going to leave this to the jury to decide as the trier of fact as to whether or not a mistaken belief is reasonable. So that objection is overruled. And next one, Mr. Glad.
Judge, the state additionally objects to the second full paragraph on page 11. It is an additional part of the application paragraph for mistake of fact. So the state would object to that as well.
Overruled.
The final objection the state has, Judge, is on page 13 of the court's charge. That first paragraph that we discussed previously, beginning, even then you may only consider, the state asks that state of mind of the defendant be added to the list of permissible purposes for consideration of extraneous bad acts. Because Judge, that was the reason why the state moved to admit that evidence, was in addition to the listed uses under 404B, which is a non-exclusive list, the state specifically argued that that evidence was relevant to the state of mind of the defendant.
Is that your last objection?
Yes, Judge.
Mr. Mullen?
No objection, Your Honor.
So we will add state of mind following accident.
Yes, Judge.
I think the only other things I was left to consider was whether or not we will have the recitation of the various felony offenses that someone might protect themselves against: aggravated kidnapping, murder, sexual assault, aggravated sexual assault, robbery, or aggravated robbery. Right?
Yes, Judge, and
You wanted all of the other crimes omitted except for murder.
yes, and that's both in the elements of self-defense on page 6, and to the extent the court is leaving in Castle Doctrine, it's the same list on page 7. And then additionally, there was the additional language for the instruction on failure to retreat.
I'm going to leave that recitation of other felony offenses. I think that was your objection 3 and 5, is that correct? So those objections are overruled. I need to make a correction to add state of mind. And how, well, oh, I'm sorry, Mr. Muller, did you have any?
Oh, no, I'm sorry, Your Honor, I was just, nothing further, Your Honor.
Okay. Did you have any objections to the charge?
No objections from the defense, Your Honor.
So I need to add state of mind on page 13. How long would you all like to argue?
No more than an hour.
Perfect. That's exactly what I was hoping for. I'm assuming you are splitting your time.
Yes, ma'am. Mr. Fine will open, I will close.
Mr. Fine will open. Mr. Fine, would you like a warning of some sort?
Yes, Your Honor, I'll use 20 minutes, will you let me know, please?
After 20 minutes.
Yes, Your Honor.
And Mr. Hermes, what kind of warning, if any, would you like?
Would you let me know, Judge, when I've got 5 minutes left?
5 minutes remaining. Mr. Rogers, how will you use your time? Will you do all of the arguing?
No, Your Honor, we're going to split it. Mr. Shook will open.
I think that the judge will give us
I'm sorry.
Sorry, Judge, we're talking among ourselves. The
I
microphone's
know.
on.
Yeah, I hear a lot of talking you all do. Sometimes it's interesting. Okay, Mr. Shook, you will open.
Yes, Your Honor. You can
And
just tell me when I've used 30 minutes.
after 30.
Thank you.
And I'm assuming you're closing, Mr. Rogers?
Yes, Your Honor, if I could just get a 5-minute warning.
I'm just gonna tell you, if you go over your time a little bit, unless it becomes excessive, I'm not going to interrupt you. But however far you go over, I will add it to Mr. Hermes.
Yes, ma'am.
And I need to tell both of you, just so you don't accuse me of cheating on the clock, when you first get up and start your salutations and thanks and all of that, I don't generally start the clock until you get to the substance of the matter. Although I need to bring the clock out here, my phone. So I am assuming you all want a quick bathroom break, and I need to make one change or addition in here. No, I'm not going to print another copy. You can all turn to page 13 and add the word state of mind. You want to kill another tree. But I will reprint at least my page 13 and add state of mind. Hopefully that won't take us over to the next page. It shouldn't. So your charges should still look identically to mine. And so I'm assuming you guys want a quick break. I need a quick break to fix this.
Yes, ma'am.
So let's bring the jury in at 10:15.